Hello everybody, welcome to Trial TV Live. I am the Squeegee of Justice. Thank you for joining us. Let me just check my audio real quick before I continue on. Seems to be working, cool. All right, how's everybody doing? This is a Monday before New Year's Eve, so we're picking up on our rewatch of New Hampshire versus Mauricio Guerrero. He is the OnlyFans stalker that was in the attic of Rachel Nunez's house. Well, actually it was her mom's house. So let me see, how's everybody doing? Dream Landry, Shirley Roth, Crystal Limited Edition. How are you guys? You're not feeling well? Oh, sorry to hear that. I hope you feel better. We'll send you love and light back. Therapist, hello. Morning for you still, yes. Little Miss, good to see you. Who else is with us? Julie, good morning. Good evening, Gordon. How are you guys? Kerviel, good to see you. Kathy Smith, hello. Oh, Florida PI Sam, how are you? Afternoon for us, yes. Holly, hello. You're lurking and watching. It's time to bake your jalapeno poppers. Nice. That sounds great. All right, so so we left off on Friday with New Hampshire versus Guillermo. Mauricio had just gotten through with his cross and his redirect, so he actually took the stand. He was the one and only person that took the stand. He was on for 2 days, and then the defense rested after that. So I could have gone and continued on with closing arguments and the verdict, but attorney Nick Starro is going to join us after this, so at 3 p.m. So I wanted to not just have him on in a bubble, so I wanted to do closing arguments, verdict, and then have Nick come on and talk about what he did when he watched this. So I thought that would be interesting for us. All right, so I am going to get this party started. Let me squeegee myself down here and turn that off. We can do that. All right, so we're going to start with closing arguments. We already heard this is still the same day, but for us it's the next day, but still the same day. And there's no closed captioning. Sorry guys, so we're just going to have to work our way through it. So closing arguments. I will see you guys on the other side.
All right, folks, as you know, this is the time for closing arguments of counsel. The defense does go first, followed by the state. You'll also notice that your notebooks are not in your chair. I do not allow note-taking during the closing arguments. Your notes will be returned to you for deliberation. Attorney Starbridge.
Thank you. Good afternoon. And we all know a lot more about OnlyFans now, don't we? One thing you can say for sure is probably not the best place to find your first. And I don't need to make light of it because it's sad. You know, this is not, again, as I said, the way to get your first. But as I said in the beginning when I first saw you guys, this case is really about intent. There's really no question that Mauricio went in the house, no question. Also no question that Rachel Nunez's mother had no idea that any of this was going on. In fact, you probably all saw Rachel Nunez's mother get the bad news that her daughter was having sex with Mauricio outside the front door right before this happened. It was first she heard it was in front of the uniforms, which is really too bad. She had no idea what was going on. But she was the only one that did, because Rachel certainly was involved in this right at the end. And the thing is, Mauricio's intent, and this is what's going to drive this, Mauricio's intent, his conscious object, his specific intent is to commit 2 crimes of crimes, either theft or invasion of privacy. So really what this comes down to is what his intent is. And actually listening to all this, and honestly, Attorney Guerrero does something very interesting. He at one point said, "Do you even know what you're doing there?" And that's a good question. Probably not. And that's the gist of this case. This isn't a burglary that's going to commit a crime of theft. This is not your traditional economic burglary. And you know that because of the way he behaves when he gets in there. The possibilities of what his intent might be, we'll see. It could be retrieving his fireplace or his TV set. It could be retrieving his glasses, his belt, his beanie. It could be these graham crackers, probably not. The most likely reason he's in there, it's almost like he's moved in there. I mean, think about this. He's got set up in the attic. He's got food, got a place to go to the bathroom. He's even made himself a key. Now, isn't that the darndest thing? Who's heard of a burglar? Goes in, makes himself a key, comes and goes throughout the day 5 times. And this is the gist of this case. This is a very confused young man, completely confused. And you can see him as he testified. He's not really, I don't want to be unkind, doesn't appear to be the most intelligent man. But he's young, hard to say really, because of his age, it's hard to tell what's going on. He's young, he's inexperienced, he's insecure. And when you think about the way he talks about himself, he starts out when he talks to one of us, it's hard to say where. Well, I'm online with OnlyFans. I mean this woman because I don't really get out much. I'm not very good looking. I'm not very interesting. No one really wants to be with me. He found someone who wanted to be with him. But what he didn't know was that it wasn't really his girlfriend. What he didn't know is he was a customer. This is the thing that eluded him. This is why there's a tragedy here. He didn't really get that he was a customer. He thinks he's in love. Well, and she tells him. She tells him, well, yes, I love you. Absolutely, I love you. I want to engage with you. But, the fact is, she's selling content. That's her job. And I'm not disparaging it. Everyone needs a job. Perfectly legal what she's doing. The problem is, she manipulates him and creates, and remember, her job description basically is fantasy. However it might be. Whatever, the client may be interested in, that's what she tries to accommodate. That's what she tries to pander to. Because, let's face it, if you're a content provider, you're in the business of selling your content, it behooves you to, get the idea of what the client wants, the customer wants, and to cater to that, to pander to it. And this is the problem in this case, is that he doesn't understand that this is a game. He thinks the fantasy is something that she shares and enjoys with him. It does not. This is all made up and contrived in her demeanor, in her presentation to Mauricio. Okay? It's all a big fantasy. She knows it, he doesn't. She knows that he doesn't get it, because she works him. She works him like a pro. She works him, and she keeps the money coming, she keeps the gifts coming, and she, frankly, keeps him interested, keeps him involved. The relationship is bizarre, it's fantastic, it's toxic. There's a real disparity between the position of control and power in this relationship. She's completely in control. She's older than he is, much more sophisticated than he is. Just look what she does for a living. She's used to dealing with people and their fantasies. He's 20 years old. He's young. He's immature. He's insecure, to say the least. His self-esteem, frankly, is less than zero. In fact, you see, he does a lot of groveling when she threatens to leave him and not be with him anymore. He sometimes he even begs. Other times, however, he says, I've had it. And he tries to break away from her. More than once, he says, they would block each other and then unblock each other. She knows what she's doing. All you have to do is block somebody and continue to stay blocked. But yet, somehow, miraculously, she unblocks him. Now, when he does it and cuts off communication, she attempts to get around that by phone calls, by FaceTimes, things like that. And when that doesn't work, she calls her friends to facilitate her being able to reconnect with Mauricio. So even though at some point he has the wherewithal to say, something's wrong with this. This isn't for me. I don't want to pursue this relationship. It's not. Maybe the light bulb's going off in his head at one point, saying, "Wait a minute. does she really love me when she says that? When she tells me she loves me, is that true? Or am I just a customer? You know, hard to say what's going through his head. What you know is he tries. She won't have it. She won't have it because this is her business, and he's your customer. And he's good for some money. He's good for money down the road. It's not, you know, the money train didn't show any signs of slowing up. You know, and that's frankly, you know, what she's into. She has all the power in the relationship, and she calls the shots. The fantasy business about stalking and things like that, you know, you can't make this kind of stuff up. You really can't. You know, had there be no, if it was just Mauricio up there saying, well, yeah, she wanted me to stalk her, you'd wonder, well, you gotta be out of your mind. Who wants to be stalked? She hadn't said it, you know, we would all have a different case here. You know, the funny thing is, as I told you before, there's largely an agreement about what happened. The question is, what does it mean? You know, largely everyone's in agreement. You know, some of the, and a lot of it came out on the witness stand when I was speaking to Rachel and the things that she said to him during this interview that she gave. One of the quotes I want to do directly from her is that she messed with his head. She says that. She wants to have him obsessed with her. She says that too. She wants him to behave like that. She wants him to follow her. She says these things. She admitted it. And you know, the thing is, she probably didn't really know that. She was just telling him that. Because that's what she does. That's her job. That's her job. She strung him along. There's another quote I'd like to throw out there. She led him on. And probably the biggest problem with all this is she keeps telling him that she loves him. That's the biggest and probably the unkindest thing about this. You know, there's a relationship here, there's no question about it, but it's not love. You know, the tragedy is that she knows it, he does not. She knows it, he does not. He was deceived and he couldn't form the intent that the state thinks you should find him guilty of. He can't form the intent because he didn't have the facts. He didn't have the facts. He didn't realize this wasn't wanted. She was telling him it was. He's ready to believe it because this is all he has. He has no other relationship. This is his first one. He's ready to believe her when she tells him that. The difference between a trespass and burglary, folks, is really intent. The question is, what was his intent when he goes in that house? You can look at a number of different things. I suggest you look at everything. You know, like I said, you know, he talks about going in to get his glasses, stuff like that, the TV set, stuff like that. The fact is, Tate's absolutely right. He really doesn't make any effort whatsoever. And that's because his intent really is to live there and stay there and be close to the object of his desire. He wants to be with her. And it's comforting to him that she's right downstairs. You know, he's in and out of that. It's almost like he's sold himself that this is a relationship and he's a roommate. You know, he makes himself a key. You know, he's not charged with doing that, but that's really what this is about. He wants access to Rachel. Okay? You know, could have been charged as you know, entering with the purpose of the crime of stalking. The fact is, she's told him that she wishes to be stalked. This is part of a game that they play. In order to find him guilty of burglary, you have to find his conscious object, his specific intent is to commit the crime of theft or to commit the crime of evasion of privacy. Trespass is a little bit different. Trespass, in order for him to commit a trespass, he has to be aware that he's not supposed to be there. That is more of a fit because, as I said to you folks before, Rachel's mother wasn't in on it. You know, Rachel was, not her mom. What's interesting about this case is Rachel told him before that if you don't get out of here, we call the cops. She said that more than once. She said that on the evening that Mauricio encountered the police department. Remember, she actually texted him. Now, this is a woman who says, I'm terrified, 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 but the fact is, she says in a text message, are you here? If you're here, you get out of here, I'm gonna call the cops. I know you're here, I know you're here. She's not spending time on 911 saying, help me, help me, help me. She's saying, get out of here. She's saying, get out of here. And if he had, may not be here, because this is a cycle with her. She says, get out of here, get out of here, get out of here. And if he had gotten out of here, it was on his way back to Pennsylvania, odds are that the next text he would have gotten was, I've changed my mind, I love you, I want you to come back. Because he does that. Attorney Garrard talks about, all this stuff, it's not in writing. It's a stalking game, it's not in writing. Actually, it is. There are some things that aren't right. Remember, when he's there in December, and she finds him there, and she yells at him and says, get out of here, get out of here, get out of here. On the way back, she writes to him saying, I didn't mean, I miss you, I do want to see you. I wish you were here. I love you. The next day, she says, I don't want you to ever come up here unannounced again, but it was a little hot. It was a little hot. That's a difficult thing to reconcile with, she's a victim of stalker. She cultivated the stalking story. This is part of the fantasy that they were playing together. And again, like I said, the problem is he doesn't know it. This is something she's contrived. He doesn't know that he's actually a customer. But again, Rachel's mother wasn't knowing that. Rachel Nunez lies repeatedly. Mauricio isn't truthful with the police either. And that's not entirely a shock. Here's this, young man who really doesn't have a lot of experience with anything. He's 20, first girlfriend, and all of a sudden he's in an interview room with all kinds of police. He didn't want to say, my girlfriend wants me to stalk her. What a shock, that he didn't want to tell the police that. Some things were absolutely true. He has stuff there. Well, that could be it. I could be there to get my stuff. The last thing he wants to do is tell these big guys I'm me and my girlfriend on OnlyFans, and I'm engaged in this weird stuff. That didn't come up when he was talking to him, even though that's what it's about. It's not about TV sets. It's not about fireplaces. It's not about graham crackers. It's about this fixation he has with her that she's invited. It's not just, if you want to talk about who's lying to who, that frankly she's concealing this with possibly the end of, maybe he'll go away, I won't have to talk to him or do anymore. Because the first thing she does on this evening is lie to the dispatcher, and this is what she does. After she gives him a chance, get out of there, because she's texting him saying, look, you got to get out of here, I'm going to call the cops, I'm not kidding. Then, and only then, she goes into her mother's room and says, I think I saw somebody. Now, she knows who it is, she's talking to him, she saw him, she knows who it is. She didn't tell mom that. She said, I think I saw somebody, it might be a problem. So, mom listens and says, that might be a raccoon. So Rachel decides she's the one who called the police. By the way, we listened to the 911 tape. She's not scared even slightly. And what she doesn't say to the 911 operator, I know who it is, I know what he's doing, I know where he lives, I know his name. None of that. She says, I think he might be upstairs, it might be a raccoon. She knows full well it's not. The next thing she does is lie to Sergeant LaFave. Very next thing, Sergeant LaFave is there. One of the protocols, as you heard from Sergeant LaFave, one of the protocols is, we have to screen out a domestic violence potential. I asked her if there was a physical relationship, because that would make a domestic violence issue. That's her job. That's what Sergeant LaFave is supposed to do. And what does Rachel Nunez say? Physical relationship? Nope. That didn't happen. Flat out lie. She lies to her mother. She doesn't tell her mother. I didn't tell you this, Mom, but just 5-6 hours ago, we were having sex in his truck. Must have forgot to tell her mother. She fined her mother. I told her about it. I wish I didn't have to. That's when she finds out. Mauricio is being unforthcoming with the police because he's embarrassed. She's flat out lying to everybody to conceal the level of her involvement with him, to conceal it. So she doesn't have to admit that. She's like, as she told the interviewer, that she led him on, that she told him that she wanted him to behave and follow her like that she wants him to be obsessed with her, that she strung along, led him on, all these things. She doesn't want to tell anybody this. Not surprising. It's not pretty. But that's what her motive is. Her motive is to get out of this as quickly as possible. His reason he's being less than forthcoming is that, he's embarrassed. And think about that for a second. That makes sense, doesn't it? You think about this. This is the love of his life, his first girlfriend. And he's going to tell these officers that, yeah, we've been on OnlyFans, and, you know, we have sex once, twice now, and, you know, that's nothing that he's actually to tell them. And he has reason to be there beyond the stalking game, beyond the game itself. I think the line of the trial was when Attorney Garrod was cross-examining Mauricio. She was trying, and you know, the interesting thing about the direct cross is it was exactly the same. He takes a long time, he's sort of plodding, sort of pedantic, takes his time, loses his train of thought, starts to cry. He was the same way with Attorney Garrod that he was with me. That's how he is. That's what he does. So when this is going on, Attorney Garrod is trying to get him to say, well, what were you doing in there? And they were going, was it the fireplace? Was it the graham crackers? Was it the TV set? And at one point she says, and this is perfect, she says, you weren't thinking at all, were you? That's for sure. And he says, yeah, not thinking at all. Not even a little bit. He is moving in there. And one of the other telling points in this trial was when he says, well, I got some stuff and then I went up to my room. And you may remember, because it was a kind of shock. I actually said, did you say your room? You know, it's an odd thing to say, but not when you think about it. Not when you think about it. He was looking at it in his room. In his confused, sad, sex-addled mind, you know, he believes that she's his girlfriend and he wants to be close to her. That's his purpose. That's his conscious object, is to go back up to his room until this all blows over and he can be with Rachel again. That's what he meant. That was his object. Ladies and gentlemen, I appreciate your attention. Has been a lot of fun listening to about the OnlyFans stuff, but I appreciate you've done that. Thank you.
Thank you. Attorney Garrod?
Defendant was a man obsessed. Sounds like you must agree on it. But it's also very clear from looking at the evidence. There's nothing less than an unhealthy obsession that would lead someone to drive 350 miles for 5 hours to break into someone's house 4 times over the course of 3 days, sneaking in and out of their room, taking photos of their genitals, and urinating in a cup in the attic. And while the defendant can try to say that he thought in his mind that he and Rachel were together to give some sort of excuse, it was very clear, and it was very clear to him that that wasn't the case, that these feelings, whatever they were almost entirely one-sided. Yes, Rachel may have been saying things to lead you on, to make you think that they might have been in some sort of relationship, but the fact of the matter is that only one of them was sending gifts. Only one of them was leaving. Only one of them was driving to see the other one. The defendant didn't think that they were in a relationship, and he said as much to 2 different police officers who specifically asked him. He said, well, it was always this really kind of complicated, on-again, off-again thing. The defendant had a compulsion to be with Rachel Nunez. The extremes that he went to, like breaking in, stealing her underwear, prying open her windows, were not done because it was something that he thought that she wanted. They were done because he had to feed his obsession with her and satisfy this compulsion to be around her and to be around her things, to know more about her, because he wasn't going to let something like her own free will stop him from being in her life. And we know that these break-ins weren't some sort of game, stalking game that he keeps referring to. And we know that because in the hundreds of pages of text messages, it is never once referred to or mentioned. These break-ins were about the defendant trying to regain control over something that he could not control, that was out of his control. And that becomes clear when you consider what is going on in this relationship at the times that he's breaking into the house. On both January 20th and February 7th, the defendant broke into Rachel's home at a time when she had broken off contact with him. So let's look at those. You want to take that first break in January 20th, which I asked about. Remember, At that point, he had come up to see Rachel 4 different times. He had come up on the 6th, 7th for an unannounced visit, and he was turned away without any sort of face-to-face. He came up on December 12th, another unannounced visit, this time because he was concerned that she was going out to drink with her friends. Once again, he's turned away with no sort of face-to-face. On December 22nd, he comes up. They spend an hour and a half together and had sex. And then finally, on January 10th through the 13th, he comes up unannounced, and for 3 days, he makes efforts to try to see Rachel and get him to meet with her. And he leaves without getting any sort of face-to-face. And what do you have there? Well, we went through those text messages with the defendant. This fighting, this we need to be done. This is too much for me. I want this to be over. And you have a break in them speaking, where she says, I'm blocking you now. And after he's turned away, after trying for 3 days to have any sort of contact with her, what is he doing 2 days after that, while they're not talking? He's looking up burglary tools. He is looking up burglary tools because he's already planning to break into her house because she's cut off contact with him. On January 19th, she reaches out to him because she's concerned that he killed himself, but then says, now that I know you're okay, I'm going to block you again. We can't be doing this. And he says, okay, goodbye. After he says that, what does he do? He drives up to Somersworth and breaks in her back barn and comes and looks at her belongings. He does this because she had cut off contact with him and he was upset, and he needed to feed his obsession to be close to her and to be close to her things. And this is sort of reflected in the nature of that burglary. Because he doesn't go in the house on that occasion and start stealing her underwear or things like that, which he does later on. But he rifles through her childhood memories. And he does this in an effort to feel closer to her. Very odd thing to do, right? What guy cares about poetry that a girl wrote when she was in 6th grade? Well, somebody that's clearly very obsessed with her that needs to get whatever he can, and that's what he's doing on that occasion. Going through her childhood memories because he is so desperate to be with her, he will take literally anything he could get. And then you have the time frame leading up to the burglaries in February. Again, what is happening at that time? They're not speaking. The defendant even told you from February 1st to the 8th, they had stopped all sort of contact completely. He comes up on February 7th. On February 7th, he's breaking in at 3 or 4 a.m. and again, of course, in the evening. The first contact they have in 7 days is after he reaches out to her and says, hey, sorry, I didn't mean to text you, to which she immediately responds with requests to FaceTime her because she's worried that he's there. Again, in the context of this break-in, they are not together, they are not speaking, and he's upset about that. He needs to do what he needs to do in order to feel closer to Rachel. And he comes equipped with a plan. Literally a list of ways that he can feel close to her, to be in her life, to know what she's doing, because again, if she's not going to tell him of his own free will, he's going to do it without and take things without her knowledge. Put a tracker on her car, put microphones and stuff to hear her. He wants to know exactly what she's doing, where she's going, and who she's talking to. And not just a list, he comes with tools. He had looked at lock-picking tools, and now he's bringing 2 different pry bars in order to break into her home. And you keep in mind, folks, that he had 5.5 hours on that trip up to think about what he is doing. This excuse that he didn't really know or wasn't thinking clearly, it's not true, because he had ample time to consider his plan and what he was going to do when he was there. And this time, when he gets there, he's not going to feed this obsession just by going through her school items or looking at her poetry. He's going to do things so that he can be physically close to her, being in the house, taking her items so that he can have a little piece of her when he goes back to Pennsylvania. He's going to put a tracker on her car so that he can know her every move, and try to access her phone so he can know what she's up to. And the minute that he gets to Somersworth, New Hampshire, everything he does from that point on is an effort to achieve those goals or to cover his tracks so that no one finds out what he's doing. And when you walk through what he did during that 3-day time frame, that becomes abundantly clear. First, he goes when it's dark out. He's there at 3 or 4 a.m. when he knows that he's got the best chances of not being seen. He pries open the windows, but he knows that that's not going to be a long-term plan. He can't keep prying open windows and obviously get caught. And so he develops a plan in order to get the key so that he can come and go and have unfettered access to Rachel's belongings as he pleases. So he waits, either in the attic or the unfinished part of the house. It's pretty unclear, but he is so desperate to get that key that he is waiting in her house until Victoria comes down and makes the keys available to him. He comes out of his little hiding hole, grabs them, waits a little bit longer, waits until they leave, then goes and starts taking photographs of their modem, and goes back out and makes a copy of that key. He waits until they're sleeping yet again, sneaks back in and puts the keys under the kitchen island. But on that occasion, he's not just there to replace the key. Again, he wants to be around her and get her items, and he's around her items and her for over 2 hours in her house, in her attic, in her bedroom. And what is he doing? Stealing her underwear, taking pictures from Victoria's room of Rachel. He creeps back out, and as soon as he's gone, he's plotting his return. He gets breakfast, and he returns to the house with a substantial amount of food, because this time when he goes back, he knows he could be there for a while, and he needs sustenance. So he waits until she's gone, he knows that she's left, goes back with his breakfast, and truly starts to treat the house as if it were his own. Wandering around, taking photographs of her bedroom, videos of the hallway, again, so that he can go back to Pennsylvania, and he can look back through this and feel closer to Rachel, and he can look at what her house looks like and imagine himself there. He takes, on that occasion, the red bathing suit from the bottom of her floor, so you can see it in that picture, and leaves the food in the attic so that he can go back to it later. He goes and purchases the tile at 9:45 p.m. so that when he comes back, he can plant it on her belongings. But then something happens. After he leaves Target to purchase that tile at around 9:44, Rachel reaches out to him, and she texts him. And she's drunk, and he knows that she's drunk. And when Rachel's drunk, one thing he knows is that she's nice to him. So here's this interesting kind of twist to his plans. Planned on bringing him to her house, but now he's here, and now Rachel might be interested in seeing him. So he has a decision to make. Does he tell her at that point that he's here and forego the burglary, or does he continue on with his plan? It's simply too tempting, he can't help it, and he tells her, for a couple hours, what would you do if I were here? She agrees, and he sees her, but they only see each other for 30 minutes, and then she sends him on his way, yet again. He doesn't get to have sex with her, and afterwards, she kind of does this 180. You'll see, I think you saw in the messages, where she starts to get mad at him, say, don't ever come here again. I don't know what gives you the right to think you can come to my mother's house. And here he is, back again where he started, with Rachel mad at him, and this compulsion, this need to be around her and see her. So he does the same thing he does the other 2 times that Rachel's not speaking to him, when things aren't going his way, and he breaks in. He's got his key copy, but now he still needs to get into her phone, finish that part of the plan. He knows Rachel's drunk, he knows she's probably not going to wake up, but he calls her just for good measure to make sure that even that sound of her phone going off isn't going to do that. He waits for her to be asleep, and again, he breaks in. He covers the tile in tape so that it can't be detected, and he tries to figure out how to get her phone. He told you that the phone, which was in her bedroom, he picked up and was trying and attempting to unlock for a series of incorrect passcodes. He Googles, can a drunk person tell you something if you convince them? And then some other guy starts calling her, and he's so possessive and obsessed that thinks he has the right to know who this person is that he calls this number from a blocked number and takes note not only of the number but of the individual, the guy, so he can keep track of the information. He's wandering around her house for over 2 hours, and halfway through takes a picture and photograph of her vagina. And to try to pretend that he did all of these things because it was something that Rachel wanted is truly preposterous. First and foremost, when he is arrested, he mentions nothing about that to Officer Lefebvre, about this being some kind of consensual thing. He says that she had invited him over earlier, but then actively tries to delete messages in front of Officer Lefebvre, likely the ones where Rachel's saying, don't ever come here again. And the idea that she would want this or somehow be happy that it was happening follows the logic that she would have eventually had to know. And the defendant is actively trying to cover up his steps to make sure she does not find out. And the reason he's doing that is because he wants to keep spying on Rachel, going in and out of her house, and not upsetting her, because he knows that doing this would upset her. Remember, he never told her about the January 20th burglary, and he was never intending to tell her about that or about the February burglaries, because he was not trying to make her happy. He was trying to feed his own interests. Keep in mind, when she's actively asking him in January 8th, hey, I just want to make sure you're not here because my door looks weird, and I wanted to make sure you didn't break in or something. He doesn't say, oh, I'm sorry, I thought you liked that, or, well, doesn't that make you happy? He actively lies and tries to pretend like he's in Pennsylvania saying things like, I'm at work. And when he doesn't finally tell her that he is in town on February 8th, he never says anything of having arrived the day before. In fact, he says, don't be mad, but what would you do if I were here right now? If this is something that he thought that she truly wanted, he would not have to preface that with, don't be mad. And his reaction, when Rachel wakes up and sees him, is not to stay and say, hey, aren't you happy I'm here? I'm playing that sexual stalker game that you wanted. It's to run up the stairs, into the attic, cut a hole in the screen, and go out to the window, and go out onto the roof in his bare socks. The defendant knew what he was doing was unwanted, and that it was wrong, which is why he lied to the officers about why he broke in, and why he's continued to lie to them when confronted with facts that directly refute his story. We also know that he knew that this was wrong because he apologized for it. He wrote a lengthy apology note to Rachel where he never once says, I thought this was something that you would like. It was, I don't know why I did this, I am so stupid. And goes on to say that this was a scary thing for you, and I know that you'll hate me. And he tells Detective Sunderland in the clearest of terms, when asked, did she ever tell you to come in? Did she ever tell you to break in? He says no. Nothing about this defense makes sense. Nothing about it fits with the actual facts of the case. And the only one that's actually saying it is the defendant, who has lied about everything in order to minimize his own culpability. What he's doing is twisting and capitalizing on something that Rachel said in passing and asking you to take it in the most literal sense. Because doing so benefits him and is the only way he can counter all of the overwhelming evidence that he broke into her house without her knowledge. And what was it that she said? I like that you're so obsessed with me, and how come you're not obsessed with me anymore? That is hyperbole. If you're feeling frustrated and you say to a friend, just kill me now, it does not give that friend permission to kill you. And when she said these things, I like that you're obsessed with me, or why aren't you so obsessed with me anymore? Keep in mind, all she knew is that this was a guy that was sending her gifts, sending her money, sending her son gifts, and showering her with compliments and admiration. She had no idea that he was breaking in and out of her home. For someone who had bad experiences with men and incredibly low self-esteem, that kind of behavior, the gifts, the admiration, it probably felt very nice. And that's, when she says it, what she's looking for. More of that. She is not looking for the defendant to break into her attic, to come down, take videos of her vagina, and to creep back up and be in her attic. She did not ask for that. She didn't want that. No woman would want that. And the defendant knew it. He didn't act obsessed with her because she gave him the idea or thought that she wanted it. He was already obsessed with her, and she did not know what he was capable of when she made those remarks. Another thing the defense is hoping to capitalize on is that he can either get you to not like Rachel or feel upset by the way that she treated him, so much so that you ignore this glaring evidence of guilt. Now, Rachel is not the perfect victim, certainly, and I'm not here to make excuses for the things that she did or try to get you to like her, because the thing is, you do not have to like her. The law protects everyone, even the people we don't like. And leading him on, going back and forth on him, texting, toxic, or maybe even praising messages at times does not give the defendant the right to break into her house and hide in her attic. What she did was not a crime. The defendant did was. Keep in mind, there are also 2 other people living in this house, Victoria, the homeowner, and a toddler, Weston, and they certainly did not deserve to not feel safe in their home. Now, I want to talk for a minute about the charges in this case. The defendant is charged with criminal trespass for breaking in on January 20th, which we know because he takes, again, that photo of the poem at 3 a.m., and he also has a video of him attempting to get through the window, and the only way he could have taken a photo of that poem is to be physically present in the barn at that time. Now, that break-in is distinguishable from the others in February in that we have no evidence that once he was in that house, he was committing any sort of crime. And that's the difference between criminal trespass and burglary. Now, the rest of the charges, the ones from February, those are all burglaries. And it's a lot of in and out, in and out, in and out. And I want to kind of clarify that with you guys because I know the dates and the times can be a little bit confusing. So burglary, as the judge will read to you, is entering unlawfully or remaining unlawfully in a home with the purpose to commit a crime. The crime in these charges alleges either violation of privacy or theft. You do not have to be unanimous on which of those crimes he intended to commit. Only that at some point he develops the intent to commit one. We also do not have to prove that the crimes were ultimately completed. Now, theft is a little self-explanatory, but violation of privacy you might not be as familiar with, and there are a few different legal variations of that, so I'm just going to go through a few of them. And the judge will also do this. But violation of privacy can be using a device to photograph or record or transmit images or sounds in a private place without consent. It can also be using a device to photograph or record a person's private body parts under their clothing without their consent. Or it can be for the purpose of arousing or gratifying sexual desire, viewing another person without their knowledge and consent. So, for the initial entry, on February 7th, that's when he goes in initially to steal keys. So for that burglary, he has either the intent to steal keys, but he's also photographing a modem, so that would be a violation of privacy for that initial entry, which of course we know he confesses to and is found on his phone. For the evening burglary, that is when he comes back, re-enters, takes the key, returns the key, and at that point taking underwear from the hallway. So that's theft. On February 8th through the 9th, the 2 burglaries from that day. The first is after he returns from McDonald's, and he's upstairs videoing the upstairs hallway. That's a violation of privacy. Steals a bathing suit, a theft, and in the evening, when he returns, takes and views a video of her vagina, violation of privacy. Steals graham crackers, and stuff. So those are the 4 burglary charges. Now, the defense wants you to really double down on this intent issue. What was his intent when he was in the home? In order to prove a burglary, we have to prove that he either entered the home with the intent to commit a crime, or while he remained there unlawfully, formed an intent and remained there in order to commit a crime. So if he's there for some sort of unlawful reason, but he has no intent to commit a crime, he is still guilty of burglary if at some point during his entry, some point during the time he's there, he decides to commit a crime and stays there in order to do so. And we know he did this because he's there for a prolonged period of time, and he's committing several crimes, several thefts and violations of privacy. Now, the defense wants you to hold him accountable for criminal trespass, and that's for a reason. It's a less serious crime. But the defendant did some incredibly egregious things when he broke into Rachel's home. And he needs to be held accountable, and it's your job to hold him accountable for the crime that he actually committed, and not some watered-down version of it. I said in my opening that the defendant went from being attracted to infatuated and to obsessed with Rachel. It is what happened, and it is demonstrated in his escalating behavior, where over the course of 3 months, he goes from sending expensive gifts, to driving long distances, to breaking in and filming her, and stealing her belongings. He's getting more and more frustrated by the fact that his relationship isn't working out with Rachel, and this is his solution to feeding that obsession. These break-ins were not some sort of consensual thing, but were done at times when Rachel was blowing him off and he was feeling desperate. Rachel leading him on may have not helped to prevent what happened, but it's certainly not an excuse, and it's certainly not a defense. What she did, whatever she did not deserve what happened to her, and her mother and son especially did not deserve what happened to them. The defendant needs to be held accountable for the crimes that he committed, and I ask you to find him guilty of 4 counts of burglary, 1 count of criminal trespass, and 2 counts of violation of privacy. Thank you very much for your time.
Thank you. Members of the jury, the evidence and arguments in this case have been completed. I will now instruct you as to the law that applies, and you will then retire to decide a verdict in the charges before you. You will have a copy of my instructions with you in the deliberation room. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach a verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions that I am about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law that you must follow in reaching your verdict. It is up to you to decide the facts in the case. You must decide the facts solely from the evidence in this trial. You should decide the facts in this case without prejudice, without fear, and without sympathy. You must then apply the law given to you in these instructions to the facts, and in this way reach a fair and just verdict. There are certain matters that you may not consider as evidence. I will discuss those matters first, and then I will turn to the discussion of what you may consider. The fact that the defendant has been arrested and charged is not evidence of guilt. The charging documents, called indictments and complaints, are simply a way of giving Mr. Guerrero notice of the charges against him. They are a formal way of accusing him of a crime in order to bring him to trial. You must not consider the charging documents as evidence of guilt of the defendant. The possible punishment of the defendant if you return a guilty verdict should not influence your decision. The duty of imposing sentence is for the judge. You should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. You will recall that from time to time during the trial, I struck from the record certain testimony, and I instructed you to disregard such testimony. You are instructed not to consider in any way any evidence stricken from the record in your deliberations of this case or in reaching a decision. You have heard the lawyers discuss the facts and the law in their arguments to you. These arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers have stated the law differently from the law as I explain it to you in these instructions, then you must follow these instructions and ignore the statements of the lawyers. If the lawyers have stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. During the trial, the lawyers made objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustained an objection or excluded any evidence, you must not guess as to what the answer or evidence would have been. If I overruled an objection, you must not give any special weight to such evidence as a result of my ruling. If you believe that I have expressed or suggested an opinion as to the facts in my rulings, or how you should decide the case, I have not done so, and you should ignore any such opinion that you believe I may have suggested. It is up to you alone to decide the facts in the case. Having addressed what you cannot consider in deciding this case, I will now turn to what you should consider. In short, you should consider only the legally admissible evidence, which in this case consists of the testimony under oath of the witnesses during both direct and cross-examination, and the exhibits which have been admitted into evidence. In reviewing the evidence, the length of the trial, the number of witnesses, or quantity of evidence are not important considerations. Rather, it is the quality of the evidence that is important. There are two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge, that is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. So let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. Hypothetically, this courtroom has windows to the outside. You look out and see that it is raining. That would be direct evidence that it was in fact raining. You could see it. Now assume that the courtroom has no windows, but as you are sitting here, someone walks in wearing a raincoat and carrying an umbrella, and both are dripping wet. Since you cannot see outside, you have no direct evidence that it was raining. But on the facts I've asked you to assume, it would be reasonable and logical for you to conclude that it was raining outside. That is all there is to circumstantial evidence. You infer on the basis of reason and common sense from an established fact the existence or non-existence of some other fact. You should consider both types of evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both. But you must decide how much weight to give any evidence, whether it be direct or circumstantial. However, there is a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of the charged offenses, then in order to convict, you must find that the totality of the evidence excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence. This circumstantial evidence rule does not apply to direct evidence. If there is a conflict between witnesses who offer direct evidence concerning certain facts, you should decide which witness to believe, if either of them. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, should decide which witness to believe, if either of them, and whether, based upon all the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. In summary, you should consider all the evidence in this case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. In deciding whether the state has proven the charges against Mr. Guerrero beyond a reasonable doubt, you must decide the credibility of the witnesses. That is, it is up to you to decide who and what to believe. You as jurors are the sole judges of the credibility of a witness and the weight their testimony deserves. If there is any conflict between what a witness says and other evidence, then you must decide what the facts are. Simply because a witness has taken an oath to tell you the truth does not mean that you have to accept his or her testimony as true. You should carefully scrutinize all of the testimony given on both direct and cross-examination, the circumstances under which a witness has testified, and every matter in evidence which tends to show whether a witness is worthy of belief. For example, you may consider the following factors: a witness's motive not to tell the truth, the consistency or inconsistency of the witness's testimony, the accuracy of the witness's memory, the witness's intelligence and his or her state of mind, the witness's appearance, attitude, and behavior on the witness stand, the witness's opportunity and ability to observe the matters as to which he or she has testified, whether the witness impresses you as having an accurate recollection of these matters, any relation a witness may bear to any party or side of the case, the manner in which a witness might be affected by your verdict, the extent to which, if at all, a witness is either supported or contradicted by other evidence in the case, and any bias, friendship, or animosity a witness may have for or against other people in the case. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted, nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You should consider these factors in evaluating the credibility of any witness, including a law enforcement officer. In evaluating the credibility of a law enforcement officer, you should use the same tests that you applied to the testimony of other witnesses. In no event should you give the testimony of a law enforcement officer any more credibility or less credibility simply because that witness is a law enforcement officer. After making your own evaluation of credibility, you should give the testimony of a witness such credibility as you think it deserves. You may accept all of what a witness has said, you may reject all of what a witness has said, or you can accept some and reject some of what a witness has said. In determining the credibility to be given to the testimony of a witness, you should use your common sense, your good judgment, and your life experience. The rules of evidence ordinarily do not permit a witness to testify as to his or her opinions or conclusions about issues in a case. An exception to this rule exists for expert witnesses. An expert witness is someone who, by virtue of education, training, or experience, may have become knowledgeable in a particular technical, scientific, or specialized field. If such knowledge or experience may be of assistance to you in understanding some of the evidence or in determining a fact, an expert witness in that field may state an opinion as to the relevant matters in which he or she is an expert. You should evaluate the testimony of an expert witness just as you would consider other evidence in the case. Thus, in considering what, if any, weight to give to the opinions of an expert, you should consider whether the expert has sufficient education, training, or experience to render a reliable opinion on the matters as to which he or she has testified, whether the expert took advantage of the opportunity to make a thorough investigation before rendering an opinion, whether the facts upon which the opinion is based are supported by the evidence, whether the reasons given in support of the opinion appear sound, and the extent to which the opinion is supported or contradicted by other evidence in the case. As with any witness, you may accept some, all, or none of the testimony of an expert witness. During the trial, you heard testimony by witnesses testifying to you here in the courtroom about statements made prior to trial, either orally or in writing or by recording. The general rule which you must follow is that statements you heard about that were made before trial may be considered by you only in deciding the credibility of the trial witness who is said to have made the statement prior to trial, not for whether what was said in that prior statement is actually true. Thus, if a witness made a statement before trial which you determine was not consistent with what the witness testified to here at trial, then you may use such a pretrial statement in deciding whether to believe what the witness testified to at trial. If a witness made a statement before trial which you determine was consistent with what the witness testified to here at trial, then you may use such a pretrial statement in deciding whether to believe what the witness testified to at trial. You may not use such statements made by a witness before trial as proof that the factual assertions in that statement are true. Such a statement made before trial by a person who testified as a witness at this trial is only to be used by you in deciding whether to believe what that witness testified to at trial and may not be considered as substantive evidence. So I have addressed what you should not consider and what you should consider in rendering your verdict. I'm now going to discuss how convinced one way or the other you must be. This is referred to as the burden of proof. As you are instructed during the general selection process, there is a presumption of innocence that applies and continues throughout this trial until the state convinces you beyond a reasonable doubt that the defendant is guilty of each and every element of the offenses with which he's been charged. Under our federal and state constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. He enters this courtroom as an innocent person, and you must consider him to be an innocent person, unless and until the state convinces you beyond a reasonable doubt that he is guilty of each and every element of the alleged offenses. If, after all the evidence and arguments, you have a reasonable doubt as to the defendants having committed any one or more of the elements of the offenses charged, then you must find him not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crimes charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the offenses charged beyond a reasonable doubt, you should find the defendant guilty. I will turn next to a discussion of the definition of the crimes with which the defendant is charged. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts, an intent and an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his intentions were. The word intent refers to what a person mentally believes his physical acts will accomplish. The word acts refers to a physical deed. Unless a person both intended and acted to do something criminal, then that person has not committed a crime. In this case, there are several charges for you to deliberate. Your duty is to deliberate only on the charges as I am about to describe them to you. You may notice that not all the charges originally read to you are the same. You are not to speculate about why. Instead, you are to deliberate only the charges as I describe them to you. Each of the charges against the defendant constitutes a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt on each. The fact that you may find the defendant guilty or not guilty on one charge should not influence your verdict with respect to the other charge or charges. In other words, you should evaluate each charge individually. The defendant is charged with 4 separate counts of burglary between February 7 and February 9, 2022. 3 of the counts have identical elements of proof, and I will address those 3 counts first. Charge ID ending in 114C on or between the 7th and 9th of February 2022. It is alleged he committed the offense of burglary in that with the purpose to commit the crime of violation of privacy and or theft therein, he entered or remained unlawfully in 34 Highland Street, an occupied structure that was not open to the public at the time in which he was not licensed or privileged to enter. The second is charge ID ending in 115C, on or between the 7th and 9th of February 2022. He committed the offense of burglary in that, with the purpose to commit the crime of violation of privacy and or theft therein, he entered or remained unlawfully in 34 Highland Street a second time, and such residence is an occupied structure that was not open to the public at the time in which he was not licensed or privileged to enter. And charge ID ending in 910C, it is alleged on or between the 7th and 9th of February 2022, he committed the offense of burglary, in that with the purpose to commit the crime of violation of privacy and or theft therein, he entered or remained unlawfully in 34 Highland Street a third time, and such residence is an occupied structure that was not open to the public at the time in which he was not licensed or privileged to enter. The offense of burglary has the following material elements, each of which the state must prove beyond a reasonable doubt. Thus, the state must prove that the defendant acted purposely, that the defendant entered an occupied structure, and that at the time the defendant entered or remained unlawfully in that occupied structure, he had the purpose to commit the crime of invasion of privacy and or theft inside, and that the occupied structure was not open to the public, and that the defendant did not have permission to enter. The term purposely means that the state must prove that the defendant had the conscious object to do certain acts or to achieve a certain result. That is, to enter or remain unlawfully in an occupied structure without permission, and to commit the crime of invasion of privacy and or theft therein. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means that the defendant desired to cause a certain result or to do prohibited acts. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do the particular acts. Whether the defendant acted purposely is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there's no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted purposely. An occupied structure is any structure, building, vehicle, boat, or other place used for overnight accommodation of people or used for carrying on business inside. It does not matter whether anyone who uses the premises was actually there when the crime occurred. Yes. Yes.
Well, that's weird. She asked to approach in the middle of his jury instruction. I wonder if he got something wrong. Is she correcting the judge? Huh. Interesting. All right, let's find out.
Folks, so to this point, I have defined for you the term purposely as it relates to burglary and the term of occupied structure as it relates to burglary. As I indicated, one of the elements is that the state must prove beyond a reasonable doubt that the defendant entered or remained unlawfully in the occupied structure with the purpose to commit a crime therein. And in this case, it is alleged that he committed either or violation of privacy or theft. So I'll now define for you the crime of violation of privacy. The crime of violation of privacy is defined as committing any of the following acts unlawfully and without the consent of the person entitled to privacy. 1, installing or using a device for the purpose of observing, photographing, or recording the private body parts of a person, including genitalia, buttocks, or female breasts, or a person's body underneath the clothing. Or 2, installing or using any device in any private place for the purpose of observing, photographing, recording, amplifying, or broadcasting in such a place. And a private place is defined as an area where one may reasonably expect to be free from surveillance, including the interior of a dwelling or other area where private body parts may be exposed. Or 3, without the person's knowledge or consent, knowingly views that person in a place where that person would have a reasonable expectation of privacy and does so with the purpose of arousing or gratifying his sexual desire. The crime of theft is defined as obtaining or exercising unauthorized control over the property of another with the purpose to deprive the person of the property. To obtain means to bring about a transfer of possession of the property. Property is anything of value. Purpose to deprive means a conscious object or intention to withhold the property permanently or dispose of it under circumstances making it unlikely that the owner would recover it. The fourth count of burglary alleges a burglary of a residence at night, and this is charge ID ending in 138C. and alleges on or about the 7th and 9th of February 2022, he committed the offense of burglary in that, with a purpose to commit the crime of violation of privacy and or theft therein, he entered or remained unlawfully in 34 Highland Street a 4th time, and such residence is an occupied structure that was not open to the public at the time, in which he was not licensed or privileged to enter, and such entry was at night. In order to prove this offense, the state must prove the following elements or parts beyond a reasonable doubt: that the defendant acted purposely, that he entered or remained unlawfully in an occupied structure that was the dwelling of another at night, that at the time the defendant entered or remained unlawfully in the occupied structure, he had the purpose to commit the crime of invasion of privacy and or theft inside, and that the occupied structure was not open to the public and that the defendant did not have permission to enter. The term occupied structure is, as I defined it earlier, with the addition that for purposes of this charge, you must conclude beyond a reasonable doubt that the occupied structure was the dwelling of another. The term night means the period 30 minutes past sunset and 30 minutes before sunrise. The definitions of the offenses of violation of privacy and theft are as I defined them above. As with all of the charges you are to decide, your verdict, whether it be guilty or not guilty on a charge, must be unanimous. That is, all 12 jurors must agree on the verdict as to each element of the offense. In order to find the defendant guilty of a burglary charge, the jury must be unanimous as to each element of the offense. With respect to the element of the intent to commit a crime at the time the defendant entered or remained unlawfully in the occupied structure, you must be unanimous that he intended to commit one of the 2 offenses alleged in the indictment, violation of privacy or theft. You do not need to be unanimous on which one. That is, by way of example, some jurors may conclude that he intended to commit invasion of privacy. Others may conclude he intended to commit theft. So long as all 12 jurors agree that he intended to commit an offense as set forth in the indictment at the time he entered or remained in the occupied structure, that is sufficient to find that the state has proved this element of the offense. If the jury unanimously agrees that the state has not proved beyond a reasonable doubt that the defendant intended to commit an offense when he entered or remained unlawfully in the occupied structure, then you must find him not guilty. If you decide that the defendant is not guilty of the crimes of burglary as set forth above, then you should go on to consider and decide whether he is guilty of a similar but less serious crime. That is, if you unanimously agree that the defendant is not guilty of burglary, then you should go on to consider the lesser offense. If you find unanimously and beyond a reasonable doubt that the defendant is guilty of burglary, your deliberations end on the burglary charges and you need not consider the lesser offenses. A similar but less serious crime is different from a more serious crime in one of 2 ways. Either it requires a less serious physical act or requires a less serious mental state. In this case, if you find that the defendant is not guilty of burglary, then you should consider whether he is guilty of criminal trespass on each of the charges. In this case, criminal trespass is defined as knowingly entering or remaining in an occupied structure when he was not licensed or privileged to do so. Knowingly means that the state must prove that the defendant was aware that his acts would cause the prohibited result. That is, that he knew that he was entering or remaining in an occupied structure when he did not have permission to do so. The state does not have to prove that he specifically intended or desired that result. What the state must prove is that the defendant was aware or knew that his conduct would cause the result. You will have a verdict form to complete, and the lesser charges will be set forth on the verdict form. Now, the defendant is charged with a separate offense of criminal trespass on or between the first and last days of January 2022 as follows, charge ID ending in 940C. in that he entered 34 Highland Street, an occupied structure that was not open to the public at the time, in which he was not licensed or privileged to enter. As I stated a moment ago, the offense of criminal trespass has several elements or parts, each of which the state must prove beyond a reasonable doubt. Thus, for this separate charge, the state must prove that the defendant knowingly entered an occupied structure which was not open to the public, in which he was not licensed or privileged to enter. That mental state of knowingly is as I defined it just a moment ago. The next offense is invasion of privacy. The defendant is charged with 2 counts of invasion of privacy on or between February 8 and February 9, 2022. Charge ID ending in 047C alleges in that the defendant did, for the purpose of arousing or gratifying sexual desire, knowingly viewed RN without her consent or knowledge in her bedroom, a place where she would have a reasonable expectation of privacy. This offense has several elements or parts, each of which the state must prove beyond a reasonable doubt. Thus, the state must prove that the defendant knowingly viewed another person without that person's knowledge or consent, that the act occurred in a place where the person would have a reasonable expectation of privacy, and the defendant's purpose was for arousing or gratifying his sexual desire. The term knowingly is as I defined it earlier in these instructions. The second count is charge ID ending in 048C. In that the defendant did unlawfully and without the consent of RN, a person entitled to privacy therein, used a device for the purpose of recording images of her private body parts. This offense has several elements or parts, each of which the state must prove beyond a reasonable doubt. Thus, the state must prove that the defendant used a device for the purpose of recording or photographing images of the person's private body parts, that the person did not consent to the recording or photographing, and that the recording or photographing took place in an area where the person is entitled to privacy. The term private body parts means genitalia, buttocks, or female breasts, or a person's body underneath that person's clothing. Ladies and gentlemen, the principles of law given to you in these instructions are intended to guide you in reaching a fair and just verdict in this case, which is important to both the state and to Mr. Guerrero. You should decide the facts of this case without passion, without sympathy, and without prejudice, but with honesty and understanding. You should be conscientious of a just result in this case, as that is your highest duty as officers of the court. Now that all the evidence is in and the arguments are completed, you will be free to talk about the case during deliberation. In fact, it is your duty to talk with each other about the evidence and to make every reasonable effort you can to reach a unanimous agreement on the material elements of the crimes charged. Talk with each other, listen carefully and respectfully to each other's views, and keep an open mind as you listen to what your fellow jurors have to say. Try your best to work out your differences. Do not hesitate to change your mind if you are convinced that other jurors are right and that your original position was wrong. But do not ever change your mind just because other jurors see things differently or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. No one will be allowed to hear your discussions, and no record will be made of what you say, so you should all feel free to speak your minds. Listen carefully to what the other jurors have to say, and then decide for yourself if the state has proved the defendant guilty beyond a reasonable doubt based on the law as given to you. Should any member of the jury panel leave the deliberation room for any purpose, you should stop your deliberations. You should only deliberate when all deliberating jurors are present to hear and participate in the discussion. Once you have finished your deliberations, please notify the court officer, who will let me know that you have a verdict. You will return to the courtroom where, in response to inquiry by the clerk, the foreperson will announce the verdict here in open court on each of the charged offenses. If you are unable to reach a unanimous verdict on any or all of the charges, please indicate in writing that you are unable to reach a unanimous verdict on the charges and give the paper to the court officer for delivery to me, and I'll give you further instructions at that point. I do suggest that the first issue you address when you reach the deliberation room is to select your foreperson, and I'll leave it up to you as to how to do that. The duty of the foreperson of the jury is to act very much like the chairperson of a committee, making certain that each and every member of the jury is given a full and fair opportunity to present his or her views and opinions on all or any of the issues presented to you for determination. You are each instructed to consider each other's views and opinions, and in the final instance, reach your own conclusion. In the event you have a question about my instructions or the legal issues in the case, put the question in writing, have the foreperson sign the question, and write down the date and time that you gave it to the court officer. The court officer will present the question to me for a response, which I will furnish you after I've had an opportunity to discuss the question and the proposed answer with the lawyers. Now, I cannot comment on the evidence, as that is not my role. As I said previously, it is up to you to evaluate the evidence, and you must use your own recollection of it. It's been my experience that some juries will, as soon as they get into deliberation, send out a note asking if they can have a transcript or a recording of what happened in court, and the answer is no, you cannot. You have to go by your own individual and collective memories as to what the evidence was. You will have the exhibits with you, but you cannot get transcripts or recordings, which is my long-winded way of saying don't ask. So I am about to make a random selection to determine who will serve as the one alternate in the case. So while the alternate will not be participating in the deliberations at this time, that alternate does perform a very important function. We need to be certain that we have 12 members of the jury to deliberate the case to conclusion. If a member of the jury is unable to complete the case, the alternate ensures that we have 12 members to complete the deliberations. The alternate juror is still a member of the panel, even though they will not be deliberating at this time. Because it may be necessary for the alternate to join the deliberations, I instruct the alternate that while you remain segregated from the deliberating jurors, you are not to discuss the case with anyone. And if you do join the deliberations, I will give you further instructions at that time. And before I select the alternate, and I do so randomly from the 13 tickets that I have here, so for the rest of the afternoon, I do require that the alternate stays here at the courthouse. If deliberations go into tomorrow, the alternate does not have to report tomorrow, but you do have to make sure that the bailiff has your emergency contact, cell phone, email, the quickest way to get a hold of you, just in case we need to press you into service tomorrow, okay? You'll need to report to the courthouse, obviously, if you are called. So I will see to it that the exhibits that have been entered into this case and a copy of my instructions are delivered to you. Also, your notes will be returned to you for your personal use in deliberations. Please keep in mind my earlier instruction that your notes are only for your own personal memory aid and are not to be used as some sort of authority to persuade other jurors. As I did mention earlier, you will have a verdict form. Each of the charges is listed. For the burglary charges, there is also listed, if you find the defendant not guilty on a burglary charge, you'll answer the question of whether you find him guilty or not guilty on a criminal trespass charge. Otherwise, the verdict form is self-explanatory. Any further input on the instructions before I release the jury? This is where things get very high-tech. So I drew the alternate juror of number 13. Juror number 13, so make sure you speak to the bailiff about your emergency contact information. The bailiff will show you where to sit this afternoon. All right, and thank you. All right, folks, you now are free to deliberate the case, and good luck.
All right.
It was funny, I texted you.
No, we had a hot mic there for a moment. I love hot mics. All right, so before we get to the actual verdict, I'm going to just read through because we have time. I'll read through the what we just went through, which was closing argument. But before that, Crystal Bonet became a Patreon, Rabbit Ears. Thank you very much for that. Appreciate that, Crystal. All right, so we heard closing arguments, which was interesting because usually it's state, defense, state with a rebuttal, but this was just straight up defense and then state. So that was kind of different for me. Anyway, so defense started out saying Mauricio was a confused young man. What burglar uses a key? He doesn't appear to be the most intelligent person. I thought that was kind of a ding. That must have hurt. Why would he say that? He says that she's selling content that's illegal, and her job description is fantasy. Mauricio doesn't understand this is made up, and she knows it. She works him like a pro. She says that she's older and more sophisticated. Well, she's 24 at that time. She has a 2-year-old. I guess she's a little bit more wise to the ways of the world, if you will. She says this is Star Branch says that she's used to dealing with people and their fantasies. Mauricio is young and insecure. His self-esteem is less than 0. I would argue that both of their self-esteems are pretty bad. That they would block each other, unblock each other, block each other, unblock each other, kind of like teenagers, if you will, which they weren't too far away from that. When he does it, she attempts to get around it and then calls friends to reconnect. So when he blocks her, she tries to figure out a way to get around that. When he blocks her, when she blocks him, he just lets it go. So fair enough, fair enough. She messes with his head. She wants him to be obsessed and to follow her. She says all of this. And she does. She does say all that. Again, she's no angel. We're not saying that Rachel is, innocent in this, but she is morally and ethically wrong. He is legally wrong. She never did anything illegal. He definitely did. That's the difference here. She strung him along. She led him on. She says that she loves him. The difference, and he talked about the difference between trespassing and burglary. Burglary is intent, and we've heard them talk a lot about that. So what was his intent? He needs to be aware he was there for trespassing. He didn't want to tell the police his girlfriend wants me to stalk her. Didn't want to tell the police his girlfriend is OnlyFans and into weird stuff. I don't know why not. Fixation with her that's that he's invited. Fixation he has with her that he's invited. So that was his defense, that he's saying, well, she kept inviting me. I would drive away and then she would call me like an hour later and tell me to come back. That she wanted me to obsess over her. I don't know. Seems like a stretch, but he said while he was on cross, he takes a long time. He cries, he loses his thoughts. That's the same as he was with me. And that's Star Branch saying that. So remember how long and painful his responses were? Oof. He's confused. He has a sex-addled mind. And he goes up to his room until this all blows over. Remember he said, I ran up to my room. Oh, no, I ran up to the attic. So he had this huge Freudian slip there. And that was it for defense. Not much of a defense. Basically that he's immature and didn't know any better. That was the defense. Not buying it. I don't think you guys are either. Because we took a poll, and I'll tell you what the results of that poll were in a minute. State gets up, says unhealthy obsession that leads someone to drive. Yeah, what is that unhealthy obsession that drives 6 hours one way, to break in, to take photos of somebody else's genitals? He thought in his mind they were together, but it was clear the feelings were one-sided. Rachel was saying things to lead him on, but only one of them drove and broke in. Again, Rachel is saying just words. Again, words aren't necessarily illegal in this case. He's the one that took action on that. He had a compulsion to steal her underwear, be around her things. The break-ins were a part to gain control over something he was not in control of. I thought that was kind of interesting. So he's not in control by her saying, playing him like a yo-yo. And I agree, she was definitely doing that to him, but those are just words. it was up to him to say, I should not be driving 6 hours without her consent, without her knowing it, and then breaking in. Again, she didn't tell him to do that, per se. Then the timeline leading up to the break-in. I thought this was good. So December 6th through the 7th, unannounced a visit, turned away with no face-to-face. December 12th, unannounced visit because he is concerned about her going out with her friends, turned away with no face-to-face. December 21st through the 22nd, spent 1.5 hours together, and they did have sex that day, night. Then, so that's 1, 2, 3, and then the other 3 in January. January 10th through the 13th, turned away for 3 days. He fought afterwards. They fought afterwards. Rachel blocks him, not speaking for days following that. January 15th, the defendant starts searching for burglary tools, and he looked up pry bars and lock-picking tools. Then January 19th, Rachel reaches out to make sure he hasn't offed himself, and then blocks him once she finds out that he is okay. She blocks him. So that's a 3 a.m. break-in at her barn, photographing her poetry. He never tells Rachel that he was there. So that's against the law. No matter what she did, that's against the law. He rifled through her personal belongings, including childhood memories. He put the tracker on her car and monitored her phone. He waits to get the key. This was all in February 8th and 9th. He waits to get the key. He was either in the attic or in the unfinished part of the house. They weren't sure. He takes pictures of the modem. He makes a copy of the key. Goes to, I think it was Home Depot to make a copy of the key. He sneaks back in, replaces the key in the kitchen aisle. In the kitchen island. This is when he steals her underwear, takes pictures and videos of the house. Remember that? And he said he did it because he felt that it was messy. The house was messy. That's a really weird answer. He gets breakfast because he'll be there a while. Rachel is drunk. She gets drunk at that point. She texts him. And then he Googles, can a drunk person tell you something to convince you? I'm not quite sure I got that right, but that was weird. Someone calls, so he takes note of who that is. Yeah, so he's climbing up the stairs, going into her bedroom, and he sees her phone, and some guy calls. So I think he was trying to get in. Oh, then he stars 69. They didn't talk about that, but they did in the trial. This is when he takes a photo of her genitals. So she's in a robe, in bed. He lifts the covers and takes a video of her. And then Emily says, it's truly, truly preposterous that she wanted all of this, right? What person would say, sure, do all of that? First reaction is to run and not stay and say, hey, this is what you wanted, right? So when she says, I'm going to call the cops, why didn't he just stay and say, you told me you wanted me to do this. Why would you tell me to do this? If his first reaction is to run. Usually you run when you feel guilty instead of staying there and saying, you told me to do this. And then she said, if you say to your friend, just off me, you don't expect your friend, just off me now, you don't expect your friend to actually do that to you. It's hyperbole to say, grape me or stalk me. She's not looking for Mauricio to break in and take pictures of her genitals. Mauricio was already obsessed with her, and she didn't know how much further he could take this. So she had kind of this fear that she wasn't sure how much further he would take this. Rachel is not the perfect victim, and Emily was not trying to get the jury to like her. Leading him on and texting doesn't give him the right to break in. I thought that was pretty good. Leading him on and texting does not give him the right to break in. Plus, there were 2 others, Mom Victoria and son Weston, who was 2 years old. They didn't deserve it. So very, very good points. Then she talks about criminal trespass versus burglary, entering unlawfully with intent to commit a crime. You don't need to be unanimous on that. Violation of privacy is the use of device without knowledge or consent, and the judge talked about that. Break-ins were not consensual, and Rachel was blowing him off at the time. Rachel was leading him on is not an excuse for what Mauricio did. Very, 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 I thought a pretty good closing by the state. Then we had jury instructions from Judge Howard. He talked about 4 separate counts of burglary, that you don't need to be unanimous. And if you find not guilty of burglary, then you can go on to the lesser offense, which was criminal trespass, which is knowingly entering or remaining when you're not invited. And then, so that was for the February 8th through the 9th. There were 3 There was 4 separate charges. 3 of them were for the January 8th through the 9th, and then another one was for January 22nd. Then he talks about the invasion of privacy. There are 2 counts there. One of the counts was just viewing, that he did so for the purpose of arousal, and he knowingly did so with that person's consent in a known private place. So first invasion of privacy is him just looking at her. The second invasion of privacy is using a device. Basically the same thing. He did so without consent and in a private place. He randomly selected one alternate. That was juror number 13. All right, so let us get to the verdict. Are you guys ready? Oh, let me read. Let's see. So we did a poll, and actually, yeah, everybody voted. 31 votes. We had 93% guilty, 6% not sure, 0% not guilty. So nobody thought that he was not guilty. 93 of you thought that he was guilty. So let's watch. Let's watch and see what he is. All right, let me pull this up. Sorry. All right. All right, see you on the other side.
All rise, jury enter. Please be seated.
Right, good afternoon, ladies and gentlemen. Mr. Foreperson, it is my understanding that the jury has reached unanimous verdicts on all of the charges before it. Is that correct?
That's correct.
So at this time, what I'm going to do is ask the clerk to take the verdicts from you orally here in court. What she'll do, you have the verdict form in front of you. She'll track the verdict form and ask you what your verdict is after each charge. Madam Clerk.
Thank you, Judge. Sir, is to charge ID number 1948114C, charging the defendant with burglary on or between February 7 to 9, 2022. How does the jury find the defendant guilty or not guilty?
Guilty.
Is that the verdict of all of you? I just need that. Thank you. Moving on then to the second charge ID number 1948115C, charging the defendant with burglary on or between February 7 to 9, 2022. A second time, how does the jury find the defendant guilty or not guilty?
Not guilty.
Is that the verdict of all of you? And given that you found a not guilty as to that, how say you on the lesser included offense of criminal trespass, does the jury find the defendant guilty or not guilty?
Guilty.
Is that the verdict of all of you? And moving on to charge ID number 1977910C, charging the defendant with burglary on or between February 7 to 9, 2022, the third time, how does the jury find the defendant guilty or not guilty?
Not guilty.
Is that the verdict of all of you? Having found the defendant not guilty of that, how say you on the lesser included offense of criminal trespass? Do you find the defendant, does the jury find the defendant guilty or not guilty?
Guilty.
Is that the verdict of all of you? Moving on to charge ID number 1948138C, charging the defendant with burglary on or between February 7 to 9, 2022, a fourth time. How does the jury find the defendant guilty or not guilty?
Guilty.
Is that the verdict of all of you? Moving on to charge ID number 1977940C, charging the defendant with criminal trespass on or between the first and last days of January 2022. How does the jury find the defendant guilty or not guilty?
Guilty.
Is that the verdict of all of you? As to charge ID number 1992047C, charging the defendant with invasion of privacy, parentheses, viewing, on or between February 8 to 9, 2022. How does the jury find the defendant guilty or not guilty?
Not guilty.
Is that the verdict of all guilty? And finally, as to charge ID number 1992048C, charging the defendant with invasion of privacy, parentheses, recording, on or between February 8 to 9, 2022. How does the jury find the defendant guilty or not guilty?
Guilty.
Is that the verdict of all guilty? Thank you, sir. You may be seated.
All right, thank you, Mr. Guerrero. You can be seated. Ladies and gentlemen, I want to thank you for your service in this case. You are discharged. You are free to leave the courthouse if you wish. However, I would like to thank you personally. You're not obligated to stay in the deliberation room, but I will be around in a few minutes to address you before you leave, just to thank you for your service. All right, but again, you're not obligated to stay. You've probably seen enough of me at this point. And so thank you very much.
Please rise.
Be seated. And so the next matter is to schedule sentencing on the guilty verdicts. Since they are felonies, is the defense requesting a pre-sentence investigation?
No, Your Honor.
State, do you wish to have? And how much time do you think you need to prepare for sentencing? And then we'll talk about how long you think the sentencing hearing will take. State, how long do you think you need to prepare?
Not long, as soon as your work is on.
Well, no, it doesn't need to be that quick, but a month or two to make sure that the defense can do any kind of sentencing investigation it wishes to do.
I would ask that not exceed July.
So, Attorney Guerrero, how long do you think the state's case, sentencing case would take?
My little presentation would be about an hour.
Half hour? Attorney Stalker?
Well, we have family members here, so I would suggest at least half an hour, 45 minutes, get it out.
All right, why don't we schedule for 90 minutes? Madam Clerk, is that a time that you can schedule now, or do you need to issue notice?
I think I need to discuss with you, Judge, and issue notice. If I can do that.
All right, are you, as opposed to be comfortable with simply issuing a notice for sentencing?
Yes, sir.
All right. Mr. Guerrero, what will happen next is the clerk's going to send out a notice for the sentencing hearing. It will likely be somewhere in that July timeframe. It could be a little sooner, might be a little longer, depending on where we can find the 90 minutes. I do want to remind you that as you are on bail, you do have to appear for sentencing. If you do not, you could be arrested and charged with a separate offense. Do you understand that?
Just the bail, I know we made accommodations for the removal of the bracelet when the jury was present, so I just want to have understanding that what we were going back to the original bail order.
That was my intention. So, Mr. Guerrero, you will be equipped with the, you don't have to stand up, that's fine. You will be equipped with the GPS monitoring system again before you leave the courthouse today, and you'll remain on GPS until sentencing. All right? All right. Any other issues? All right, thank you. All rise.
All right, so he remains out on bail for his sentencing. I have a sentencing coming up, so stick around for that. Don't go anywhere. So let me see if I can break this down. So he was, charge 1, he was found guilty of burglary. Charges 2 and 3, and this is all from February 7th through the 9th. So there are 4 counts of burglary, and he was found guilty on counts 1 and 4. On counts 2 and 3, he was found not guilty, but he was found guilty of criminal trespass. That's the best I can do without actually seeing the jury, the jury form in front of me. But yeah, they did not revoke his bail pending sentencing. Yep. So counts 2 and 4, he was found guilty. 1 and 4, he was found guilty of burglary. Counts 2 and 3, not guilty of burglary, but guilty of criminal trespass. So they definitely found him guilty of being in this person's home without being invited. That's pretty clear. Then there's the January 22nd. He was found guilty of criminal trespass at that point in time. All right, then we go to invasion of privacy, which was February 7th through the 9th when he was in the attic. Count 6, he was found not guilty, but count 7, he was found guilty. So he was found guilty of filming her lady parts, but he was not found guilty of entering her room without her consent. That's a really tough one because she was sleeping. Did she really say, "Come into my room while I'm sleeping"? I would have found him guilty on that one too. But all right, so that's where we stand with that. Then we have sentencing, and sentencing is not long. And then don't forget, we're going to have Nick at 3, so another 45 minutes. I'm going to try and time this so we don't have too much time in between. Nick is going to give us his breakdown of what he did when he covered this trial. So I'm interested to hear his take on that. All right. We have closed captioning on this one, guys. That's cool. All right, closed captioning on this one. And I gotta do some fancy footwork here. Move myself over here. Move my logo over here. And, okay. Move that over here. All right. All right, let's stick, I'll see you guys on the other side. This is the sentencing.
So I have decided upon what I believe to be an appropriate sentence in this case. This case does obviously involve extremely unique circumstances that have been largely restated here at this hearing, and all of the facts and circumstances came out at trial. It's a complicated case. In the end, my job is to determine for Mr. Guerrero what is a reasonable and proportionate sentence to the offense and his individual characteristics. I have also considered the arguments made by the state and its sentencing recommendation, the arguments made by Attorney Starbranch and his recommendation, and the statement made by Mr. Guerrero's mother, as well as his own allocution here today. I've taken into account the aggravating factors, which include that this was a dwelling of another at night. It appears to have been motivated by an intent to violate Ms. Nunez's privacy and to satisfy a certain obsession that Mr. Guerrero had with her, and I'll talk more about that in just a moment. So there are some aggravating circumstance to it. The mitigating circumstances are Mr. Guerrero's age, his relative lack of maturity, particularly from a social standpoint, and his complete lack of any criminal history. So for all of, and also I've taken into account the conventional considerations in sentencing, such as the need to specifically deter you from future criminal conduct. I do not expect that you'll be in trouble with the law again, and I've built a sentence here that will help ensure that. General deterrence, obviously, the sentence has to have some component to send a message to the community that this type of behavior won't be tolerated and will be punished. And then as well, rehabilitation, and there's a significant component of this sentence that deals with rehabilitation. It does appear to me that you have at least begun the process of rehabilitation. That has not been, I think, in my judgment, significant at this point, and I do intend to impose requirements on you that are geared toward your rehabilitation. The offense and the unique circumstances of the offense do require a period of incarceration. And so, on the following charge IDs, in docket number 22 CR 64, charge ID ending in 114C, that's a Class B felony burglary. And then 3 criminal trespass charges, 115C, 910C, and 22 CR 68, charge ID ending in 940C. You are sentenced to the House of Correction for a period of 12 months. You have pretrial confinement credit of 16 days. This sentence is stand committed commencing today, and these 4 sentences are concurrent with each other. You are to participate meaningfully in and complete any counseling, treatment, and education programs as directed by your correctional authority. You are ordered to be of good behavior and comply with all the terms of the sentence. And then the sentencing order includes the following language. This sentence does not include a recommendation for administrative home confinement. If at any time during the sentence the superintendent deems AHC to be conducive to the defendant's rehabilitation, the superintendent shall notify both the court and the state prior to release, and if requested by the state, a hearing shall be promptly held under RSA 651-19-3. In docket number 22 CR, I believe it's 68. This is the Class A felony burglary. The sentence is as follows. You're sentenced to the House of Correction for a period of 12 months with no pretrial confinement credit. All of this sentence is suspended during good behavior and compliance with all the terms and conditions of this order. Any suspended sentence may be imposed after a hearing at the request of the state. The suspended sentence begins today and ends 5 years from your release from the House of Correction. This sentence is consecutive to your House of Correction sentence if imposed. In addition, you're placed on probation for a period of 3 years on this sentence upon the usual terms of probation and any special terms determined by your probation officer, and probation begins upon your release. Subject to the provisions of RSA 504A43, your probation officer is granted the authority to impose a jail sentence of 1 to 7 days in response to a violation of a condition of probation not to exceed a total of 30 days during the probationary period. If you violate your probation and your probation is revoked by the court, you may be sentenced up to the legal limits for the underlying offense. The underlying offense is a Class A felony and is punishable by up to 7.5 to 15 years in state prison. You are to participate meaningfully in and complete any counseling, treatment, or educational programs as directed by your correctional authority or your probation officer. You're ordered to have no contact with Rachel Nunez, Weston Nunez, or Victoria Bork, either directly or indirectly, including but not limited to contact in person, by mail, phone, email, text message, social networking sites, and or through third parties, or any digital or virtual platform of any kind. You're ordered to be of good behavior and comply with all the terms of the sentence. Further, you shall continue in counseling and provide proof as directed by your probation officer. Within 90 days of release from the House of Correction, you shall obtain a psychosexual evaluation by a qualified provider and follow all recommendations as a condition of the suspended sentence and your probation sentence. With respect to the state's request that I qualify Mr. Guerrero as qualifying for registration with the sex offender registration, I do not find by clear and convincing evidence that the offenses here were driven by a sexual compulsion, as I understand that term to mean under the statute. Nevertheless, even if it did, I do not find that Mr. Guerrero's circumstances suggest that protection of the public requires registration, and therefore he will not be required to register as a sex offender. Attorney Starbridge, are there any objections to the legality of the sentence?
No, Your Honor.
Attorney Garrod?
No, Your Honor.
All right, thank you. So, Mr. Guerrero, the sentence is now imposed. What happens next is you're taken into custody by the sheriff. You'll be brought across the street to the House of Correction. Good luck.
Sorry, Fala, did I give a spoiler? I thought I was putting it in at the appropriate time. All right, let's do a little recap here. All right, so unfortunately, because when I was first finding this trial, and I saw that sentencing was only 7 minutes 55 seconds, so basically 8 minutes, I'm like, that kind of stinks. So we missed the state and the defense with their statements. We missed any kind of impact statements. Apparently his mom talked. So I'm kind of bummed about that. I'll try and find it. If you guys, hey, if anybody can find it. Yeah, 8 seconds ahead. I think I'm more like 20, 20 seconds ahead. But hey, if anybody, yes. So, okay, let's break it down. So Judge Howard says, motivated by intent to violate Rachel's privacy and to satisfy his urgings, that's why he found him guilty. Mitigating circumstances were his age, social maturity, and no criminal history. So he did something wrong. It wasn't cool, but he shouldn't be thrown in jail for, 15 years. I think that was the maximum. So he says he needs to deter you from future criminal activities. He needs to send a message to the community, and he also needs to have some sort of rehabilitation. He says he does believe Mauricio has begun the process of rehabilitation. So, I guess he was already doing some counseling, I guess. So for the guilty for burglary, he did 12 months, and for the 3 criminal trespassings, he also did 12 months, but those were concurrent. And he gave him 16 days already served. And then he also told him you need to participate meaningfully in counseling. Now, so that was concurrent. So yeah, he gets a year. Basically, the end result of all that is a year. Burglary for 12 months. He suspended that for good behavior from today until 5 years after you're released. So he still has to be good for 5 years after he's released, and then he's on probation for 3 years. He's not to have any contact with Rachel, Weston, or Victoria. He's ordered to have a psychosexual evaluation. Thought that was kind of interesting. And he is not required to register as a sex offender because he doesn't feel the public needs to be protected from. Well, he has to stick with that therapy. BAP, that's the thing. Has he already been released from prison? This was last year, so possibly. Let me see. Is he gone already? Mauricio Guerrero, let's see, update. Because if this happened, when was this trial? So this happened May of 2023, and he was sentenced, say, even in September, so theoretically, yeah, he should be out. Oh, I wish I could hear his. I wish I could get his. I wish I could get their impact statements. I would really love to find that. He's got to be out, but I'm not seeing anything of him being out or not. There's no news that he was actually released. Released from prison. Because theoretically he should be, he should be out. Yep, so July 19th he was sentenced to 1 year. July 19th of 2023, so he should be out at this point in time. So this was July 19th. July 19, 2023. So, yes, he should be out by now. He should be out by now. What did Mandy? Yeah, he's out. I looked him up. Okay, cool. I couldn't find anything, so thanks, Mandy. Hey, Mandy, if you find the impact statements on YouTube without anybody's talking on top of it, send that to me. There's something on Court TV, but it looked like there was, or another channel, W somebody or other up there. They had a press release, and I didn't want to take that from them. All right, so do you guys have any questions? Because Nick's going to be joining us in about a half an hour at 3 o'clock Eastern. I have us portaled over, so I hope you guys can join us then. Nick is going to talk about what he did when he looked at this trial, and I think he went from the end of it and he went backwards to the beginning. So I'm really, really interested to hear what he has to say. So he's not in the New Hampshire Department of Corrections. Okay. So where did he end up going? I know you can't post any links, Mandy, but if you can post a sentence or two of where he was. But yeah, theoretically, he should have been out this past July, August at the latest, because that's 12 months. If it was July 19th, then he should have been out, August. It's funny that he say 12 months, because usually they'll say 348 days or 762 days, because 12 months, yeah, it's interesting that New Hampshire just goes 12 months versus 365 days. Was he sent to jail versus prison? Yeah, good question, Julie. Mandy, you're the one that's on it. Give us some deets if you can. Seemed like a well-crafted sentence to me. Clearly some thought was put into it. Yeah, Ken. Yeah, I like this judge, actually. Judge Howard. I kind of liked him. What trial are we doing next? I want to do... now, I'm not going to be on tomorrow because it's New Year's Eve, and I've got a lot of running around to do to get ready for New Year's Eve and our anniversary. But we're going to be streaming live tomorrow starting at 4 Eastern. So kind of like we did Christmas Eve, we're going to do a New Year's Eve. So join us. Therapist, jail is typically for 1 year or less in Texas anyway, yeah. Fowler says, Virginia, 12 months or less is jail, a year or more is prison. Mandy says, I think he would have gone to the county jail, not prison, because it was only 12 months. Okay. Yeah, usually after you're convicted, you get sent to prison. When you're just, being tried or whatever, you're in jail. Ken says, yeah, he might have done the year in jail. That's not uncommon in my area for sentences of a year or less. All right. Little Miss, jail is usually under 365. Okay. So he spent his time in jail. So another less than a half hour, we're going to join, Nick's going to join us. I have another stream, and I also have a, oh, thank you, Widespread. Yes, tomorrow is Aaron and I's anniversary. Nick is going to join us for a recap, and then tomorrow morning, we're all off, but then 4 o'clock Eastern, we're going to do a New Year's Eve, and we're going to go until the ball drops our time, which will be midnight, so please join us for that. That'll be a lot of fun. We've got special guests and friends and all kinds of fun people are going to be showing up, kind of like on Christmas Eve, if you caught that. And then the next trial I want to do, I have to make sure it's all there, which I think it is, but the next trial I want to do is Grant Amato. And he apparently offed his family because he was hooking up with a Bulgarian. It's kind of like in OnlyFans. So I think that's going to be the next one I'm going to do. Again, it's going to be a rewatch. But thank you, Kathy. How many years for you and Aaron? 17. 17, little miss. Take your anniversary off and spend some time. Well, we are. Actually, we don't go anywhere. So we end up just hanging out, watching TV, going on YouTube, and just partying. So we're going to do it, but we're going to do it with you guys. So Aaron's totally down with it. It's going to be fun. We'll have fun. The judge did not think he belonged in prison. Yes, I agree. Fala, can someone tell my boyfriend I am required to be here? I don't want to go to his cousins with all the people and people drinking. Yeah, we don't want to travel either. We really haven't. You know, we got married on a boat in Fort Lauderdale, which was great. We went up and down the Intracoastal. It was a blast. We set sail a little bit before 9, got married, and then went up for an hour and a half and came back for an hour and a half. So it was about a 3-hour tour, and we were on the boat when the ball dropped, and it was so much fun. But ever since then, we do not go out for New Year's Eve because too many drunk people are out there. Just too many things. Too many things. Yes, little miss. Grant is a psycho. I don't know much about him other than I don't know. There's a lot that there's a couple others cases that we want to do. The big one coming up would be Billy Wagner. I think he starts the 6th, but we're not sure if he's actually going to be shown. Meaning, Florida PI Sam said the other trials of his family they would like just black out the audio and the video, so people would be up there testifying and you could not even see or hear them. So if they do that, I'll cover it. But if it's the first person that does that, I'm gonna bounce. I'm not gonna cover a trial where I can't see people testifying. Oh, Krista, your daughter turns 27 tomorrow. Very cool. Well, happy birthday to her. Momo Shark, we've been sober since 2011. Good for you. Good for you. Fala, it's at a house, so that helps. So not traveling much. I just don't want to. Yeah, I know. I hear you. Yeah, I mean it's fun. We love to go out and hang out with people. But guess what? We like to hang out with our YouTube family. We're going to be doing that, and we're going to trust me. I'm going to have enough friends and no family, but enough friends, and to be on. It'll be a blast. I hope you guys join us. I hope everybody that's in here, all 28 of you, join us. I think it'll be a lot of fun. So. All right, guys, I am going to end this. There is a redirect. I did a redirect, but I'll put this, let me see here. Just in case the redirect does not work. This is, okay, so join Nick and I. So that's the link. I just dropped the link. Here, I'll put up here too. Nick and I stream. All right. So I'm going to add a redirect. You guys can join us via that way, or you can just click on that. You are a lot of fun. Who, Fala? Who's a lot of fun? Yes, Little Miss, of course. Oh, Brooklyn, how you doing? Only 2 or 3 witnesses opted out of the Billy Wagner. Billy Wagner? George, right. So that was his son, I think, right? I really don't know much about it other than real peripherally, so I don't know much about it. So only 2 or 3 witnesses. All right. Well, we're going to cover it. We're going to cover it, but Brooklyn, if I see some people bouncing, or if I see them doing that, like for 2 or 3 hours, I'll be like so bummed, because how's that going to work? You know, that's not going to be cool. Anyway, I'll make that game time decision. So that's going to be the 6th. But before that, I think I'm going to do that Grant Amato. Yeah, Grant Amato. It looks like we have all the days on a solid channel. And it's about 6 days. 6 or 7 days. So that'll be good. So we can do that... we can do that Thursday and Friday. All right, finally got your portal helmet on. Cool. And let's see. He's a nutcase, yeah. I think the judge took Rachel's manipulation behavior into consideration as well, Mandy says. Yeah, no, but she didn't break the law. That's the bottom line. She was morally and ethically incorrect, wrong, however you want to say it. But she did not break the law, and she never once said, come on over and take pictures of me naked. Come on over and break into my house. She didn't say that. He says that she said, you know, obsess over me, and she said, I like it when you obsess over me, but, you know, was she saying, come over and break into my house with my son and my mom? You know, she did not say that. So that's where he just took it too far, you know. And he's young. I get it. I hope that this was a learning experience. It seems like it was. He now has a rap sheet, so how's that going to go over with the ladies? right? Don't some ladies like the bad boys? Are they gonna like that? Is he gonna be? Is he gonna be now? Oh, does he have a teardrop? I wonder. Did he get a teardrop in jail? Sorry. Okay, let's see what else. Oh, Green Eye Cat, how you doing? Happy last Monday. We're doing fine, Green Eye Cat. Thank you for joining. We're going to have Nick Starro join us in about 20 minutes or so. I am going to take a little break, about a 15-minute break there before Nick joins us, but just kind of going over this trial. If you have any questions and what we're coming up with, we're going to be streaming. We're going to be off tomorrow morning, but we're going to stream at 4 o'clock tomorrow afternoon to ring in the new year with our family, our YouTube family. Fala says, if we went to court for moral wrongs, there wouldn't be enough time in the day. Yeah, that's true. Isn't that what church is for? Isn't that what religion is for, is to assess your moral wrongs? Hello, over from RA. Oh, hello, Sunshine Sarah. Thank you for joining us. Cool. So did RA do a portal? That would be cool. I appreciate that. Yeah, are you guys coming over from RA? That's cool. Thank you, Scott. Thank you, RA, for doing that. I didn't know you were live today. I thought you were taking off. But awesome if you are sending people over. Appreciate that. Thank you. Yeah, some big trials coming up this year. Billy Wagner for sure. Stephen Stearns for sure. We're going to be at that one. Graham Agati, therapist you know. Oh, he didn't, but I came over. Oh, cool. Well, thanks. Therapist you know said Graham Agati starts in June. Corey Richins is going to be happening this year. 2025. Those are some big ones. Who else? Courtney Clenny has a pre-trial on the 3rd, this Friday. We'll probably cover that. What else? Looking forward to New Year with my favorite YouTubers. Very cool. You going to join us, Green Eye, then? We're going to be on at 4 tomorrow, so that'll be fun. Yeah, I got some errands to run. We usually do sushi. That's one of our things we do for New Year's Eve. So I'm going to go get sushi. I'm going to pick up some pizza. We don't really want to cook. So New Year's Day, we're not cooking, right? No. Yeah, Christmas we cook. We did lasagna. And then New Year's we just blob and just, watch some TV. Oh, you know what? I want to watch, what's that, Accused you guys were talking about? That looks really good. Oh, Kristen, tap, tap. Is this thing on? Yeah, that's a great handle, Kristen. Cool. Kristen, tap, tap. Is this thing on? Thank you for coming over, guys. Really appreciate it. Oh, and by the way, we hit 5,400 subs yesterday because of Grizzly. Grizzly is rerunning Chandler Halderson, and we covered that around Halloween. And we were at 5,380, I think, subs. And she missed a part or something, and she went to our channel to get the part that we had streamed. So she gave us a shout out, and we've gotten 50 subscribers from her since the weekend. So thank you, Grizzly, and whoever's here from Grizzly. Really appreciate it. Accused, guilty or innocent on Hulu. Yep. I will definitely check that out. So Momo Shark, you want a barbecue package and having close family over. That's nice. Karen Reed, thank you, therapist. Absolutely. You're so over the Adelsons. Yeah, well, it's Wendy. We're waiting for Wendy. She's really the one that I want to see go under the microscope. Donna and Charlie, sure, they had a hand in it. Harvey, I'm sure how could he not have had a hand in it? But I like finger foods and we play board games. Low key, stay home. Green-eyed, yeah. That sounds good. Yeah, Gisela has is it Gisela or Gazella? Gisela has a really huge following. She does. She has like 4,000 people watching her yesterday when she said that. And as soon as she said that she used us and Aaron commented and she pulled our comment up, and she's great. I mean, she's always been really kind to us. As soon as she said, thank you, Trial TV Live, we had like 40 people come over. So that was awesome. Widespread. You're not over the Adelsons, but you're over Karen Reed. Yeah, well, one way or the other, that has to be resolved. And that's not going to be until April anyway, I think. They kick that to April. It could be resolved in a heartbeat. Bev just needs to say it's done, or there's not enough evidence here, or Morrissey needs to say we're not going to continue on. That's how it can be over. But guess what? They're not. They're digging their heels in, and they're going to look like fools. And that's where I stand. I am fully 100%. She is not guilty, not even close to being guilty. G like Grant, not George. So Grant. So Gazella. Grant. Gazella. Thank you, therapist. Well, we're going to play some games, right? Therapist, we're going to have some trivia on tomorrow during our live stream at 4, so that'll be fine. G is sweet and kind. She is. Yes, so Therapist has come up with some really cool trivia questions. I came up with a few, so hopefully we can meld those all together, and you guys will join us tomorrow at that time. So, Haley, Haley Mouse, how you doing? You love a game or quiz, but my family are spoil sports. Well, that's no fun. Well, come join us tomorrow. Haley, I know, let's see, we start at 4, so what's that going to be, about 10 o'clock your time? So you can join us in watching the ball drop, or the London Eye. What do you guys do? What does London do? I know you guys set off fireworks and you have the eye. Big Ben, do you do any? Is there any dropping of anything in London? Curviel says DOJ and FBI hiring them for an independent analysis was just crushing their entire case. I agree. Hey Joe Schmo, these notifications are whack. No worries, man. So, Joe, we're going to be going on with Nick in about 15 minutes, so stick around for that. Nick's going to join us. I am going to take a 10-minute, 15-minute break, so I'm going to go off in just a few minutes. Green-eyed cat. My daughter and I like the Exploding Kittens online. We played Taco Cat and a Little Wordy over the last few days. I'm not even sure what that is. Exploding Kittens? That sounds interesting. I'm not quite sure. I hope that's not literal and little kittens explode. Taco Cat. I like that name though. Taco Cat. That's cute. All right, guys. I added a redirect. Green-eyed cat. Let's see. Have y'all seen the burrito one? Something about throwing a burrito. That's funny. All right, gang. Chat, I am going to end this stream, and I will see you over at Nick Starro. He covered this trial, and he is going to, it's a trivia card game, and he's going to join me. I'm going to join him. We're going to get together in about less than 15 minutes. Exploding Kittens was fun for a couple of nights, but it got old pretty fast. All right, I'll have to check it out. All right, let's continue the conversation over at the stream for Nick. I portaled everybody over, but I also posted it in the, I pinned it up. So if you guys, please join us over there. I'm going to end this broadcast. Thank you so much for joining us. Thank you, Aaron. Thank you to our mods, Julie, Therapist OnlyFan was not with us today. Florida PI Sam was with us. Brat was not with us. But thank you guys for joining us. Thank you for being into this trial. I wasn't quite sure what I was going to get when I first started. I thought, oh, it's New Year's Eve. I was kind of sick and tired of, mayhem and murder and death. So I thought, well, this one sounds pretty good. It's just a stalker. Little did I know it would involve what it involved. So, guys, thanks for joining me. Please join us over with Nick. We start in about 10 minutes. I will see you over there, and I'm going to end this stream now. So thanks for joining us, and we'll see you carry the conversation over there. All right, bye, guys.